listeners, welcome to the very first episode of The Legal Minds. For today's topic, we will be discussing about the basis of global trade and the standards in global trade.
Not only that, we will also be talking about international tribunals who would settle disputes of violations of global standards in trade. Am I right, Anya?
SD, you got it right. Not only that, we will assure you that this episode will be a fun learning experience. So don't skip this vid, just sit back, relax, and enjoy.
So what are we waiting for? Let's get it started! Once again, this is The Legal Minds, your voice toward truth and justice.
Yay!
The first topic that we are going to discuss is the laws which are the basis of global trade. The laws which are the basis of global trade is the international trade laws. So what is international trade laws? International trade laws is the set of laws and agreements that govern commerce between countries. International trade laws create the rules that countries and businesses must follow in order to do business across borders. There are numbers of treaties and other types of agreement between countries that set rules for international trade and finance, such as GATT and World Trade Organization. The earliest major international trade agreement involving a significant number of countries is the 1948 General Agreement on Tariffs and Trade, or GATT. The agreement prohibits economic activity that member nations see as unfair. One of the prohibited practices is dumping or lowering prices in one geographic area in order to push out a competitor. Another prohibited practice is offering subsidies in order to disproportionately aid a certain economic sector. World Trade Organization, on the other hand, oversees the global trade rules among nations. It superseded the 1947 General Agreement on Tariffs and Trade, or GATT, created in the wake of World War II. The World Trade Organization is based on agreements signed by the majority of world's trading nations. The main function of the organization is to help producers of goods and services, exporters and importers protect and manage their businesses. The World Trade Organization is essentially an alternative dispute or mediation entity that upholds the international rules of trade among nations. The organization provides a platform that allows member governments to negotiate and resolve trade issues with other members. The World Trade Organization's main focus is to provide open lines of communication concerning trade between its members. A major facet of the World Trade Organization is the protection of intellectual property rights internationally. These include things like copyrights, trademarks, and patents. We will now going to discuss the principles of international trade law. One of the principles of international trade law is the national treatment principle. It requires that once unimported goods enter the market, they should be treated the same as locally produced goods. The same should apply to foreign and domestic services and to foreign and local trademarks, copyrights, and patents. So, for us to better understand this principle, magbibigay ako ng example. So, for example, pag si country A is nag-provide ng special tax break for its fledgling pharmaceutical industry, kailangan lahat ng pharmaceutical company na nag-ooperate doon sa country A na yon is entitled rin sa tax break na yon, regardless of whether the company is domestic or foreign. The other principle is the most favored nation principle. It requires a country to provide any concessions, privilege, or immunities granted to one nation in a trade agreement to all other member countries. Although its name implies favoritism toward another nation, it denotes the equal treatment of all countries. Most favored nation treatment is synonymous with non-discriminatory trade policy because it ensures equal trading among all member nations rather than exclusive trading privileges. So, for example, pag si country A is nag-reduce ng tariff by 5% para kay country B, sinasabi ni most favored nation na kailangan lahat ng member is magkaroon din ng tariff cut na 5% doon kay country A. So, that's all for this topic. So, ang next na magdi-discuss sa atin ay si Anya.
Now it's my turn to discuss, and the topic that I'm going to discuss about is standards in global trade. We first define what standards are. Standards is like a basis or a set of rules or criteria to which countries must be able to abide with. So, para mas maintindihan natin kung ano ang standards, i-explain ko siya ng true numbers. Let's say, numerical standard is 50. In order for you to be considered in compliance with the standard, you must be within the range of at least 47 to 53. If you are outside of that range, then you are considered in violation of the standards. So now we go on to how these standards are created. The World Trade Organization and the United Nations had a General Assembly or a meeting to which representatives from different countries join in order to share different disputes and pertinent problems na na-encounter ng mga bansa. So, through yung mga disputes na yon, nakakagawa ng World Trade Organization ng mga global standards. Kasi yung mga global standards, nagsiserve na din siya ng mga solution para maiwasan yung mga dispute na kagaya na mga mabibigay dun sa General Assembly. Every country has the freedom to create and set their own rules and standards as long as it is in conformity with the global standard given by the World Trade Organization. And the World Trade Organization stated 3 things that the country has to follow if nagbabalak sila na maggawa ng sarili nilang standards, which is first, these standards must be based on science. Second is to the extent necessary. Third, should not be unjustifiably discriminate between countries where similar conditions prevail. Yung third, sinasabi doon na syempre yung mga conditions na na-experience natin, hindi yun unique sa kada bansa. Na-experience yun ng ibang bansa. Kaya pag kinompare natin yung set of standards natin with other countries, dapat hindi siya peculiar or yung kakaiba or yung out of nowhere mo lang ginawa. Dapat nandun pa din siya. Same pa din yung mga standards. Kung mag-iiba man, hindi dapat siya malayo. But the WTO recommends na sundin lang yung set of standards na binigay nila kaysa gumawa ng sarili kasi mas unlikely na questionin ito ng ibang bansa. Also, if iba-iba yung set of standards, ito just make things difficult and complicated imbes na yung aim sa paggawa ng standards, which is to make things go smoothly. One sample situation is with exporters. Too much of standards and regulations would make things hard for exporters kasi yung mga standards is para din siyang set of rules na need sundin ng mga exporters, especially sa mga custom duties na ini-impose dun sa pagpasok ng mga product nila. Syempre, mas pipiliin nila yung mga country na hindi masyadong i-impose ng custom duties. Let's just say that it's better to keep it safe but convenient at the same time. We head into some sample standards. We first give yung binigay ng WTO kung bakit essential ang global standards. First, they are essential for advancing good governance, sustained economic development, and eradication of hunger and poverty. So now, let's head on to some of the examples of standards. So, usually, standards are related with consumer protection, specifically their safety, hygiene, healthcare, protection from fraud. So, standards are also applicable to product characteristics or what we call technical standards. To further understand them, we enumerate some of it. First is yung mga ingredients or parts included sa isang product. For example, may mga ingredient na nasama dun sa product na kung saan it may have an effect sa health ng consumer. Example, may mga poisonous or addictive ingredients like nicotine or mga chemicals or yung mga harmful substances. I-check yan thoroughly and kung pasado ba sa standards nila. Another example is yung sa automobile parts, specifically yun sa steering wheel. There are countries which requires automobiles to be either a right-hand or left-hand driving vehicle. If right-hand, it means na nasa right side yung steering wheel. Pag left-hand naman din, nasa left side yung steering wheel. Example sa technical standard is yung sa production process, especially sa food. Siyempre yung pinagdadaanan na proseso sa paggawa ng pagkain, it usually concerns machines na ginagamit. So, yung machine, it may transfer radiation sa food. So, dapat i-check din yan thoroughly. Next is sa packing. It is part of a standard kasi kung paano yung state nung binalot siya, dapat ganun pa din yung state niya the moment it reach yung destination niya. After technical standards, we have safety and environmental standards. These standards give importance to the safety of not just humans but also the environment. For example, in other countries, cars are tested to see if yung gas emissions niya ba meet the standards designed to protect air quality. So, we can say na standards take many forms and serve much more purposes and are applicable to various things from automobile, construction material, film, technology, fast food chain, and many more. So, standards are made in order to serve their purpose, which is to protect humans, animals, and plant life, and also to lessen disputes that are happening in relation with trade. Lastly, to add up, in order to check if a product is in conformity to standards, it goes through testing, certification, and laboratory accreditation. That's it. That's all it for my part. Thank you for listening.
Hello guys, now that we are done discussing about the basis of global trade and the standards in global trade, I'll now discuss to you the International Tribunals who actually handle the cases or disputes and violations of global standards in trade. But before we move on to the main discussion of this video, I'll give you an overview first of what is dispute and the two types of dispute. When we say dispute, it refers to an argument or disagreement between people or groups. Other people might agree with you. Yes. Other people may not agree with you. And this kind of situation na kung saan hindi kayo nagkakaintindihan or your idea is different from another might actually lead to a dispute. Ngayon, ano naman yung two types of dispute? The two types of dispute is, first one is the state versus state. The state versus state simply refers to a state filed a complaint against the other government or state. Example, China versus United States. And then the second one is the investor state. Simply lang to, the one involved here now is an investor. An individual investor filed a complaint against other governments. Example, XYZ Mining Company versus China. But I'm just going to discuss to you the dispute between state versus state. Now, let's move on. Okay, most dispute about state versus state is actually handled by the World Trade Organization. Sino ngayon tong World Trade Organization ito? WTO is the International Tribunal or the primary body governing the international trade. Ibig sabihin, this organization is actually the one who has the power or control with regards to trading internationally. Actually, World Trade Organization has 164 members. Part of it is the United States, China, Mexico, and also Philippines is part of the World Trade Organization. Ang tanong naman ngayon, ano yung mga responsibilities or other duties ni WTO as an organization? Okay, the first one is WTO is actually the one responsible for the implementation of trade agreements. Para sa tong trade agreements? Trade agreements is actually the one that will bind all the countries, and ito yung magbibigay order or coordination inside the organization to prevent dispute. And syempre, pinakaayaw nating mangyari is yung magkaroon ng war between countries. The second one is the World Trade Organization also produces research about global trade and economic policy. These researches will actually help for the development of the developing countries, especially to the improvement of their economy. And lastly, but not the least, World Trade Organization serve as a forum for the settlement of disputes between countries. Ibig sabihin, a member of WTO can bring a case to the organization and to have consultations, to have discussions and resolutions as well. Okay, one of the cases that is actually handled by the World Trade Organization is the case between the China and United States. According to World Trade Organization or WTO, United States actually broke the rules or violated the global trade rules, in which as a member of the WTO, you must provide or you must offer equal tariff rates among the body's trading partner, which is hindi ginawa ni United States. Nag-impose siya ng tariffs $360 billion worth of Chinese products. According to the United States, ginawa niya yun because they are protecting their own products, and according to the law in their country, that according to section 301, the president is actually allowed to impose tariffs to restrict foreign commerce that unfairly burdens the United States. And United States believe that China actually brings burdens to their country, and trading with them constitute unfair trading practices.
Okay, so it's my turn to discuss. For me, what I will discuss will be the International Center for Settlement of Investment Dispute and their roles and how they execute judgment. First off will be their duties. The duty of the ICSID or the International Center for Settlement of Investment Dispute is and always has been to provide a neutral and effective facility for the resolution of international investment disputes. The ICSID offers facilities for arbitration and conciliation, and the ICSID additional facility also includes a fact-finding capacity. What does all this mean? It means that they will be the settlers for disputes between investors and investments. And for their the main goal of this particular group is for their services to resolve disputes and allow investments to thrive, particularly to allow other countries to be able to invest in other countries in order to help their businesses grow. Because for in a country, the most important thing is investment, whether it is a developed or undeveloped country. In order for it to keep developing and to keep the economy afloat, they need to be able to invest in other countries. And the ICSID also helps member states to instill confidence in foreign investors. Now to the second part of my presentation, which will be how they execute or render judgment. For the ICSID, since they are an international group, they necessarily don't have rulings, but what they do have is award. And the award is the tribunal's last decision. So, kung sa normal court decision or ruling sa ICSID, ito ay tawag na award para sa kanila. And para if magka-award, kung sino yung magka-award, sila yung mananalo ng case. Any other ruling before the final award, such as a decision on liability, is not considered an award. And it cannot be used as the final decision. It can never be rendered. So, if for example, nagka-decision lang, they're still gonna be waiting for the final ruling. Kasi nga, hindi pa siya yung kino-consider sa ICSID as the last ruling. But if this tribunal, if the ICSID issues a decision on jurisdiction, upholding its jurisdiction, The decision formed will be part of the eventual award, and the award is final and binding and can be recognized and enforced in any member state that is under the ICSID. There is no appeal against an award. So, if, for example, sa Supreme Court may ruling and may pwede kang mag-appeal the award, since it's really like the last and final judgment, it can never have yung appeal, unlike sa normal court ruling. But at the same time, the post-award remedies are very limited compared to normal ruling. And these are all written under the convention. And since once the presentation of the case is completed, the proceeding is declared closed, and the award must be signed in the next 100 to 20 days, with the possibility of an extension of 60 days, which is the max. If it exceeds 180 days, it can no longer be considered the award, and it will no longer be considered valid under the convention and the rules of the ICSID, since it would be technically breaking that convention or that agreement. And for the last part of my presentation, I will be reporting a case way back in 2011. Now, in this particular case, there was a dispute over one of the greatest underdeveloped gold mining companies against a very powerful country at that time, and a very powerful leader during that time, which rewarded one of the largest awards ever in the history of the ICSID. Now, this case took place back in 2011, but the final decision, the award was given in 2016, where the Canadian gold mining company Crystalex International Corporation secured an arbitral award of $1.2 billion plus pre and post award interest for unfair and inequitable treatment and the unlawful expropriation of its investment in the La Cristina's mining project. Now, basically, what the line that I just said is explained is the Canadian Golden Company, yung Crystalex, nagpaalam sila na mag-mine sa Venezuela, which may treaty yung dalawa, yung Canadian Gold Mining Company, pati yung Venezuela. Now, what happened was, the meaning of expropriation means the treaty was violated and hindi siya sinunod ng leader. Now, see, basically, kasi Hugo Chavez, he was the newly elected leader for Venezuela, and when he came to power in Venezuela, he commenced widespread nationalization, including government takeovers of oil projects, agricultural, cement, steel, telecommunication, and especially gold mining. So basically, gusto niya maging monopoly sa country niya, sa Venezuela, na lahat siya yung may-ari and walang ibang makakahawak or makakuha ng profit basta nasa country ng Venezuela or under niya. Which, sa paggawa niya, he put Venezuela sa collision course with the international investment community, which led sa withdrawal from the ICSID back in 2012. So basically, sa pagkagawa niya nun, Now, so you remember the ICSID, they have member states. And because of what he did, when he came to power, ang nangyari is, nawala siya sa, nawala yung Venezuela sa ICSID as a member state because he violated every single treaty na nandun. Now, because of what happened, it's in recent years before this even happened, Venezuela's history of expropriation, yung pag-violate ng treaty, it wasn't the first time that this has happened. It's happened before with ExxonMobil, which is an oil company that rewarded Exxon company, which rewarded in 1.76 billion dollars, and another which awarded just $700. So it's not the same. Now, this with Crystal X, it was the highest award ever given to an investor and to a company which wanted to invest in a country by the ICSID. It was the biggest. Now, basically what happened is Crystal X complained that its rights to create, operate, and use the gold mine at La Cristinas had been destroyed by the denial of a natural resources permit by the Ministry of Environment in Venezuela back in 2008. And now, in conclusion, Crystal X considered that it had been subjected to unfair and inequitable treatment, which resulted to having proved that they lost out on 16.86 million ounces of gold, not to mention $500 million that was already invested in the project in the first place, which, which rewarded them the 1.2 billion that they basically got out of this ruling. Now, for the case that basically happened, it's not like it's a normal case. Hindi siya parang normal case na daming pwedeng mangyari. Because dito sa particular case na to, it was clear from the very start na violate nila ang rules and yung treaty and agreement. Unlike kasi sa like there were evidences you have to present, and basically what happened here was a new leader came into power, tapos he basically didn't want to agree to anything na ayaw niya. So wala siyang pake. So disagreed. Tinakbo niya yung Venezuela kung paano niya gusto without knowing yung mga prior agreements, prior treaties. So in the end, he got caught because of the complaint, because of a single complaint, and because of this, there wasn't really much na mangyari sa court na to, or sa case na to, because the award was given the decision was late, all because they had to compute how much they had to give out, yung award, how much they had to give sa Crystal X because of what they lost, not because of lack of evidence or to find whether they have to or not. And well, that concludes my presentation. I hope you learned and I hope you enjoyed. Thank you, classmates.
Alright, another video has been done. We hope you enjoyed this video and we hope you learned a lot from us.
Thank you for watching, everyone. See you on the next video. Keep safe and God bless you all. Once again, this is The Legal Minds, your voice towards truth and justice. Tapos na! Yay!